Very good morning, students. This is Suresh, your commerce teacher from Government Degree College, Kukatpalli. Today, we will learn another important topic of Indian Contract Act, that is free consent. Consent is different from free consent. So, from section 13 to section 22 of Indian Contract Act 1872 deals with consent, free consent, and flaws in consent. You all know that consent is the mere willingness, but such willingness must be free and genuine to form contract. So, consent is the binding tag that creates contractual relationship between offerer and offeree. So, in today's lecture, we will learn the definition of free consent. We will see what are the common flaws of consent, and we will also understand the important definitions of coercion, undue influence, fraud, and misrepresentation. So let us get connected to consent and free consent. According to section 13, two or more persons are said to be consent when they agree upon the same thing in the same sense. That is what we understood as consensus ad idem, right? So this definition doesn't include the word free and genuine. Someone threatened you or someone emotionally blackmailed you to give your consent or willingness to a contract. Can you call it as a valid consent? No, because consent must be free and genuine. You also try to recollect from the chapter 2, that is acceptance, wherein we understood that acceptance must be free and genuine. So here consent is nothing but the acceptance to contract must also be free and genuine. So that is the reason why law has very meticulously partitioned consent from free consent. Now, free consent is defined in section 14 of the Contract Act. According to it, the consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, and mistake, right? So if there is a coercion means a threat or a blackmail in simple language. Undue influence, someone is misusing the relationship between the parties and persuading one party to give consent to contract. Fraud, you all know, misrepresentation by happenstance, and mistake. So these are called flaws of consent. Flaws, F-L-A-W-S, flaws means defects of the consent. If these defects are not there, the consent is said to be free and genuine and deemed to be forming a valid contract. Now let us explore these flaws or defects of consent in detail, because each flaw has got its own definition in law as well as its own significance in determining the validity of consent and of course thereby the validity of contract. Now you got the point clear that consent is absolutely free from, different from free consent. Free consent is one which is free from the defects like coercion, undue influence, fraud, misrepresentation, and mistake. Now let us connect ourselves to the flaws of consent in detail. The first flaw in consent that makes it invalid is coercion. It is defined in section 15, undue influence defined in section 16, fraud defined in section 17, misrepresentation defined in section 18, mistake defined from section 20 to 22. Mistakes can be bifurcated into mistake of law and mistake of fact. Mistake of law is again ramified into mistake of the domestic laws, that is of the country, and mistake of the law pertaining to foreign country. On the other hand, we have mistake of fact. The fact can be misunderstood either by one party to contract or by both the parties to contract. That is the reason why we classify mistake of fact into mistake, that is unilateral mistake and bilateral mistake. Let us explore these terms in detail in the next slides. Before I go to next slide, let me meet my requirements of copyright. This chart has been copied from The Elements of Mercantile Law by a great author, N.D. Kapoor. Right? Well, the first one is coercion. According to section 15, coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code 1860, or the unlawful detaining or threatening to detain any property to the prejudice of any person, whatever, with the intention of causing any person to enter into an agreement. This definition looks a bit intricate, but we can make it very lucid to understand and enjoy the subject by dividing this definition into two parts. Part 1 is, if anyone commits or threatens to commit an act prohibited by Indian Penal Code. We all know what is Indian Penal Code. It determines the punishments to be imposed for various crimes and offenses. So if any activity is prohibited under IPC 1860 and someone commits it or threatens to commit and forces you to enter into an agreement, it is called coercion. So there is a famous case law, look below, Chikkam Ammiraju versus Chikkam Seshamma. It is also a very old case law, but a hallmark case law that has settled the tenets of coercion. What happened in this case is, Ammiraju and Seshamma were wife and husbands. Ammiraju threatened his wife Seshamma that he will commit suicide if she doesn't transfer the entire property in the name of his brother. So Ammiraju wanted the property of his wife to be transferred in the name of his brother. So the poor Seshamma, who wanted her husband to be alive, has transferred the property in the name of her brother-in-law. So after some time, she went to court and filed a suit that she wanted to cancel that contract. Then it is obvious to understand from this that Section 306 of IPC, Section 309 of IPC 1860 prohibits or forbids committing suicide or abetment of suicide or threatening to commit suicide. So suicide threat is a forbidden act under IPC 1860. Therefore, Seshamma is deemed to be a victim of coercion, and court has given ruling that she can cancel the contract and get back her property on the grounds of lacking free consent to the contract. Mind it please that Seshamma can exercise it as a voidable contract. Recollect it from section 2 subsection I that if contract is enforceable only by aggrieved parties, it is called voidable contract. So here the contract became voidable because the forbidden act has been applied by her husband and forced her to give her consent to transfer the property. So it is not a free consent as well as it is a voidable contract, right? Coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code 1860, right? Now the second part of the definition, or the unlawful detaining or threatening to detain any property to the prejudice of any person, whatever, with the intention of causing any person to enter into an agreement, right? So, if you detain forcefully the property of someone and force him to enter into contract, it is also a coercion. Another famous case law is there to establish this definition more firmly, that is Alvar Shetty versus Ranganayakama. In this case, there was a minor widow, her husband was passed away, and they have not begetted any children, any legal heir. So the husband's relatives were were afraid that the entire property earned by her husband will be the sole property of wife, because wife is the natural legal successor when children are not there if the husband is deceased. So the relatives of the husband were afraid that the entire property will be taken away by the young widow. So they have forced her to adopt a small boy shown by them, such that he will become a legal heir. The adopted son will also become a legal heir, right? So they have further said that we will not allow your husband's dead body for funeral unless you adopt the boy suggested by us. The poor lady was left with no option but to adopt the boy suggested by the relatives of husband, right? Adoption contract was made, adoption deed was made. Later on, she went to court and got the adoption deed cancelled. How? Because the relatives of the husband detained the property of the poor widow. Here, the dead body of husband is also property of the lady, that is the poor widow. So they have detained the property and threatened her to enter into an adoption agreement. It is also an act of coercion. Clear. So court has very clearly held that any unlawful detaining, whatever is the property, or threatening to detain any property, I am using the word any property, to the prejudice of any person, whatever with the intention of causing any person to enter into an agreement, it is a coercion and it will not have free consent to the contract. Now you got it clear? So let us recapitulate the definition once. Coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code 1860, or the unlawful detaining or threatening to detain any property to the prejudice of any person, whatever with the intention of causing any person, please, it need not be promissory, it can be any person, to enter into an agreement. Got it clear? Now let us understand what is undue influence and how it impacts consent of the contract. Well, according to section 16 of Indian Contract Act, a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other, right? So I will decode this definition into 3 points. See, if you want to say that there is an undue influence on a party who entered into contract without giving free consent, so it must fulfill 3 important conditions. Of course, the 3 conditions are very much winnowed from the definition itself. What are those 3 conditions? 1. There must be some relationship between the parties. Whatever it is, it may be parent and child, it may be teacher and student, it may be doctor, patient, it may be a lawyer and client, whatever it is, there must be some relation between the parties. Second, the relation is such that one of the parties is in a dominating position, right? For example, doctor is in a dominating position. He knows that a particular ailment can be cured with mere medicine, but he threatens the patient. unless you are operated, unless surgery is performed, you will die. What the poor patient does? He will listen to his doctor. So doctor is in a dominating position, right? Patient is in getting dominated. So first condition is that there must be some relationship between the parties. Second, relation is such that one of the parties is in a position to dominate the other person. Third, the person who is in dominating position is misusing his position to obtain unfair advantage over the other. As I told you earlier, that a doctor knows that particular ailment can be cured with mere medicine, which may cost rupees 500 to 1000. But he wanted to earn more money by performing the surgery, so he threatens the patient that unless surgery is performed, you will die. So it may cost 10,000 to 15,000. So what doctor is doing in this case? He is misusing his position to obtain unfair advantage over his patient, isn't it? So obviously the consent given by patient is not free consent, as it is induced by undue influence. Got the point clear? First, there must be some relation between the parties. Second, relation is designed in such a way that one of the parties is in a dominating position. Third, the dominating person misuses that relation to gain advantage or unfair advantage over the other person. Right? If these three conditions are satisfied, the consent given by the victim to contract is not a free consent. It can be set aside on the grounds of voidability. Right? Let us repeat the definition once. According to section 16, a contract is said to be induced by undue influence, where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. Now you are clear with coercion and undue influence? Let us now make a march towards understanding what is fraud. We all know that fraud is cheating someone, but such a simple version of understanding will not suffice the literature of law. Section 17 of Indian Contract Act has given a well-established definition for the word fraud. Accordingly, fraud means and includes any of the following acts. It can be any of the following 5 acts given below: committed by a party to contract, or with his conveyance, or by his agent. I mean, the party himself need not to commit the fraud. He can do it with his conveyance, or through his agent also he can commit a fraud. To deceive another party thereto, that is to cheat another party in the contract, or his agent. Sometimes he may cheat his agent also, or to induce him to enter into an agreement. That means only to make the other party to enter into contract, you may do any of the following acts which are fraudulent in nature. Fraud means and includes any of the following acts committed by a party to contract, or with his conveyance, or by his agent to deceive another party thereto, or his agent, or to induce him to enter into an agreement. Number 1. The suggestion as a fact of that which is not true by one who does not believe it to be true. That means whatever you are suggesting as a fact that is not true, you know it that it is not true, yet you are intentionally suggesting it as a fact. It is fraudulent act, right? Suppose I want to buy ISO mark helmet for riding a bike. You know that it is a fake ISA mark. You know that it is a counterfeit product. Intentionally, you are persuading the customer to believe that it is genuine ISO helmet. So, the suggestion is a fact of that which is not true by one who does not believe it to be true, right? Second, any active concealment of fact having knowledge or belief of such fact. Concealment means hiding. If you intentionally hide or conceal the fact which you know, which you have knowledge, it is also a fraud. But This provision is not applicable in the case of auction. Whenever we sell goods through auction or property through auction, what we do? We give prior notice and invite the bidders to come and inspect the quality of goods. So you find for yourself whether there are any faults or defects in the goods which you want to buy through auction. So we need not to reveal the facts which we know. So that is the only exemption. But in remaining cases, any active concealment of fact having knowledge or belief is a fraudulent act. The promise made without any intention of performing it. You made a fake promise. Yes, I will do it. But you don't have any intention to do it. Right? So it's a fraudulent act. Any other act fitted to deceive. Something else also you can do to cheat other party. The opposite party. It is also fraudulent. Any such omission which the law specifically declares to be fraudulent. Sometimes you need to make certain legal declarations. If you won't declare them, it is also a fraudulent act. Please recollect the mutual fund advertisements. Some 1 or 2 years ago, the caution that mutual funds are subjected to market risk. Please read the offer document carefully before investing. So this was telecast in a very fast tempo at the end of the advertisement, such that the common viewer could not understand the content of that caution. It is also proved to be fraudulent. Now the advertisements were redesigned to clearly state that mutual funds are subjected to market risk. Please read the offer document carefully before investing. Such a lucid version and slow tempo must be declared. If you omit that declaration, it is also a fraudulent act. Suppose I buy some chemical. It is inflammable. It highly exposes to flame. So there must be caution. Highly inflammable. Don't take it near to the flame. That caution must be given. If you omit that caution, it is also a fraudulent act. Clear? So fraud means and includes any of the following acts committed by the party to contract or with his connivance or by his agent to deceive another party thereto or his agent to or to induce him to enter into an agreement. The suggestion as a fact of that which is not true by one who does not believe it to be true. Any active concealment of fact having knowledge or belief of such fact. The promise made without intention of performing it. Any other act fitted to deceive. Any such omission which the law specifically declares to be fraudulent. Simply, if any of these 5 points given in the definition are committed, they are fraudulent. And consent is obtained through such actions from the other party. It is not a free consent. The contract can be cancelled by the victim. Got it? Now let us understand what is misrepresentation. Misrepresentation is defined in section 18, which means and includes the positive assertion in a manner not warranted by the information of the person making it of that which is not true, though he believes it to be true. That means you are positively believing one false activity or one false assumption as a truth, and the same you are proposing or corroborating with the other party in the contract. The positive assertion. Assertion means you are believing positively and telling the same to the other party in contract, though it is false. Right? It's a misrepresentation. Any breach of duty which without intent to deceive gain advantage to the person committing it or anyone claiming under him by misleading another to his prejudice or to the prejudice of anyone claiming under him. That means you are breaching or revoking the duty which you have to perform to discharge your contractual obligation. But that breach of duty you are innocently doing. You don't have any intention to cheat the other party. But such innocent revocation of duty is giving advantage to you or to anyone claiming under you. That means it may be you or your agent or your legal heirs are getting benefited by innocent revocation of the duty which you are supposed to discharge through contract. Right? Causing, however, innocently a party to an agreement to make a mistake as to the substance of the thing which is the subject of the agreement. So in the second paragraph, you are revoking the duty. But in third paragraph, what it means is you are causing someone, that is the other party in the agreement, to make mistake. But that mistake is the main subject of the agreement. So you don't know that you are making him to commit a mistake, but you are doing it innocently. So it is also misrepresentation. Clear? The first paragraph is you are believing a false thing as truth and corroborating and communicating the same to other party in contract. The second paragraph says that you are not performing your duty which you are supposed to do, but by innocence. Third, you are causing other party to the contract to make mistake, but that mistake is of paramount importance in determining the subject of the agreement. Clear? So the question is, I may commit a fraud, but when I am caught, I may plead my innocence. Sir, it happened by misrepresentation. Kindly forgive me. Then how to escape? Every fraudster will escape the liability in such circumstances, isn't it? That is the reason why law very clearly says, our courts have delivered judgments on various circumstances that the onus of proof of misrepresentation is vested in the hands of one who pleads misrepresentation or who claims that it is not a fraud, it is a misrepresentation. Such person has to prove that it is not fraud, it is misrepresentation. Right? It is not the challenger who has to prove. Here, the onus of proving the misrepresentation is vested in the hands of one who claims that activity was misrepresentation and not a fraud. Right? Now, let us go back to our previous chart and understand the nitty-gritty of mistake. Look at this chart. Mistake is divided into mistake of law and mistake of fact. Well, if you have committed mistake of pertaining to foreign law, so the agreement shall be void from the beginning, because we are not conversant with the law of a foreign land, so we can be exempted from performing the contract. Though the consent is not free, we are exempted from performing the contract when it is established with materialistic evidence in the court of law that the mistake pertaining to foreign law is committed. Right? Contract can be absolved. I mean, the contractual liability can be absolved by the party committing such mistake. But if the mistake is pertaining to the domestic law, it is not an acceptable exemption or mode to avoid the liability. Because we have a famous maxim, ignorantia juris no excusat. That means ignorance of law is not an exemption. So it is pertaining to your own country's law which you are supposed to be thorough with before entering into contract. So once such mistake is committed, you are held liable. The consent given by other party under such circumstances is not a free consent. So you have to compensate that mistake. Right? Now, mistake of fact. Fact can be anything. It may be pertaining to price, it may be pertaining to consideration or identification of the subject of the contract or mode of performance or terms and conditions, whatever it is. So that fact sometimes can be misunderstood. Right? Suppose only one party misunderstood or committed mistake with respect to fact. It is called unilateral mistake. You are alone committing a mistake, but the other party is not committing any mistake. So why the other party should become victim? Therefore, you have to pay compensation. The contract becomes voidable at the option of the other party who is not committing mistake. Right? Similarly, bilateral mistake. Both the parties to contract are committing mistake. No headache, no issues, both are at mistake. So the agreement itself is void. No question of converting agreement into contract. Right? Am I clear? If both the parties are committing mistake, it is invalid from the beginning, void ab initio. Next, if only one party is committing mistake, it is a unilateral mistake. It becomes a voidable contract. because the other party is not committing any mistake, right? So unilateral mistake is defined in section 20, bilateral mistake is defined in section 22, and mistake pertaining to law has been defined in section 21 of Indian Contract Act 1872. By all means, we can understand that if any flaws, that means if consent is given under flaws like coercion, undue influence, fraud, misrepresentation, or mistake, section 19 clearly says that such consent is not a free consent and the contract formed with such consent can be set aside. Clear? So these are the flaws of consent, that means the defects of consent. So if these defects are not there, it is called free consent, and only free consent is required to form a valid contract and not mere consent, please. What is free consent? Free consent is absolutely free from coercion, free from undue influence, free from fraud, free from misrepresentation, and finally free from mistake, right? So with this, discussion on free consent is also completed. Now let us take assignments. So please attempt these 3 assignments. 1. Discuss the flaws of consent. You need to write all the flaws of consent, that is coercion, undue influence, fraud, misrepresentation, and mistake, along with the chart, please. Second, explain the differences between the coercion and influence. Please try to construct a table. Left hand side you put coercion and on the right hand side you put undue influence, and try to bring out the differences between these 2 defects. Third, discuss the difference between fraud and misrepresentation. Same exercise we have to do. Construct a table, write fraud on the left hand side, misrepresentation on the right hand side, and identify the differences between these 2 terms. Clear? With this, free consent is completed. In our next topic, we will have a discussion on legality of the object. See you in the next class. Have a nice day. Bye.